Hey everyone, this is Steve Cizik. I am the of counsel tax attorney with the Harris Law Tax Division. Welcome to part two of There is no such thing as a free lunch, rise and fall of ERC employment retention credits. In part one, we discussed what ERC is and how necessarily it's been applied. And we're going to go ahead and talk about the two big items in this particular webinar that the IRS is focusing on with respect to whether you qualified and how they're going to audit you if they feel that you didn't qualify. And as some of you may know, I certainly do. Due process is a little wonky when it comes to IRS. It's a sort of guilty till proven innocent sort of situation in our system. And so if you are being audited, they are assuming that you did not follow the rules. And it's your obligation to prove to them that you did. A lot of the times with we talked about in part one, these ERC mills, we're calling, cold calling people, securing forms, filing them, and then guess what? They're gone now, so they can't speak to it. And if you didn't, meet some of these qualifications, then you're going to be stuck trying to prove that you did. Hopefully this will give you some insight as to what they're looking for. We talked about the big two. The big two are dropping gross receipts or a governmental order or action preventing your ability to have more than 10% of your gross receipts as previously before. There are some nuances with respect to 2020 versus 2021. And once again, the laws kind of changed and they were fluid. So 2021 kind of expanded as people started to take advantage of these particular credits. But then that also created some more exposure as well. So 2020, as we talked about previously, more than 50% drop in from 2019 to 2020, basically a corresponding quarter. Big point. PPP is not included. PPP cannot be included in your ERC claim. And so if you took PPP and received PPP, a lot of people I have found, if they were doing this on their own, or if their CPA was not as creative, or maybe just was overworked at the time, or maybe during COVID, they were maybe not as focused because they had their kids running around like some of us, like many of us. PPP would just be claimed straight across the board for employee payroll. And that's the easiest way to do it. You send in your payroll summary, it lines up with the PPP money that you got, credits went straight across. You can't then use those same employee wages and say that you're qualified for ERC because you already paid taxes and employee wages with government money. So they don't like double dipping. You can't pay taxes with government money and then have the government send those taxes back to you. They're basically then stealing from the government. So we don't want to have that. And certainly if that was done, we want to have an accounting of what portion of the PPP would have been allocated toward the wages. But also PPP had some nuances where you could apply portions of those funds towards operational expenses. And so the bookkeeping should have been done, and if it was done properly, to allocate PPP money towards those non-employee expenses, and then whatever was left, you would claim ERC. And so we're seeing that not as much. I think the IRS is being more lenient with respect to that because it's really just a moving of money between different boxes. But if you did have huge PPP and not a whole lot of operational expenses, staffing company, IT companies where it's really just a lot of employee wages, not a whole lot of overhead. Claiming ERC in addition to PPP can create some significant issues and an audit risk. Interesting fact: if you qualified for one quarter, you would get the following quarter automatically, even if you didn't qualify for it. So we have been able to push those forward, even where we had a client that didn't qualify in a subsequent quarter. We were at least able to eliminate the audit amount for that following quarter because the law just says, you have one, you get the other, even if you recovered more quickly, because we're going to give you the benefit of the doubt on that. 2021, it's less, so it's a more than a 20% drop as opposed to the 50% drop, which was 2020, which is interesting because 2020 was when we had all the shutdown stuff. And so obviously things carried through 2021. Why they wanted that higher threshold. It seems to me like the people were still trying to operate at the end of 2020, and they had, maybe not as much of a reduction, but far be it for me to tell Congress how to do their job. So for 2021, if you had a reduction of 20%, once again, that's compared to the equivalent quarter in 2019. If you were not operational in 2019, then you would just compare it to the equivalent quarter in 2020, which for most businesses who started operation in 2020, God bless them, but their operations were probably not very lucrative, so they typically would qualify on this one. Once again, PPP not included. People were taking PPP for 2020 and 21. PPP has its own issues with rampant fraud, but double dipping is something certainly the IRS is looking at. And if your accountant or bookkeeper was not paying attention, you could get audited, and you would want to go and either hire a tax attorney to help you address that, or go back to those books and reallocate those PPP funds towards non-employment wage type expenses. Same thing if you qualify for the previous period, then you get the next one without audit review. So that's actually a really good point. One that many don't actually know. Typically an audit agent will identify that, but they do have a ton of new audit agents. And so that's something that could be to your advantage. If you're throwing your hands up and say, they got me, you can say, well, at least I got 2 periods instead of 2 periods of not being audited, as opposed to 6 or whatever it is. The second part of the big 2 is the government order. The government order it has to be like a physical piece of paper. It can't just be like a news clipping, because those were everywhere at the time. Internet resources, things like that. They're not going to accept that. You have to physically have the order. Usually it's got a seal on it. Governments, county clerk and recorders hold these things. You can typically get it from your attorney general's office and things of that nature. Like, yeah, I remember I operated in Lincoln, Nebraska, and they had shut down my ability to plug in my generator, or whatever it is, and it has to have, specifically state that, and then the timeframes in which it would have shut you down. They have tried, being these ERC mills, and then some CPAs who are trying to get more creative, and then some business owners who just thought that they were smarter than the government, looking at this thing called a supply chain shutdown. Supply chain in their minds could be anything, right? So I couldn't drive, to where I needed to drive to, because there was a government order that was say, stay in place. My a truck that was supposed to ship my my goods got tied up in California, and therefore that reduced my ability to operate. That may be true, but that's really hard to prove, because of just basically everything had slowed down at the time. And so it would be hard to say, yeah, because of some, a butterfly flapped its wings, in China. Probably a little bit apropos for this particular discussion regarding COVID, but it's difficult, and I've had a hard time utilizing that argument, the supply chain argument, in audit. Usually I'm using more substantive arguments. I think in the particular case where we had a supply chain argument, I ended up using just finding actual government order. So that was one that was a backup argument that never really actually held any ground. So be careful when you're looking at supply chain orders. Be careful when you're looking at reduced operational hours and partial suspensions and things like that. There are nuances to it. Partial suspensions in and of itself has a very sort of particular calculation as far as what's a full suspension, what's a partial suspension, how does it apply? It's actually fairly broad. And if you've had a partial suspension of your business during a period of time, the the threshold's not actually that high to go ahead and meet it and get your ERC qualifications, but you have to still prove the partial suspension. You can't just say, oh, I just told everybody not to show up. You telling everybody not to show up, you're not the government, and that's not going to qualify for government assistance. So it'd be one of those things you really have to look at it, and we would dig into it if you did have an ERC audit, and then you were saying, look, I was partially suspended. I am a franchise and half of my business was suspended, but half of it wasn't. That's an interesting argument that we've made before and that we've seen some government responses on. So it can get fairly intense on those, but the easiest way to do it is just to have that government order in hand. Restaurant example for one of the clients that I had on an audit, for example, pizza restaurant, this is all sort of hypothetical. And there was a government shutdown federally, but this was Texas. And so if you remember the political implications in Texas, the governor opened Texas, even though the federal government wanted everything closed. And so we actually were fighting the IRS because they were saying, you're in a jurisdiction where the state has essentially made up its own mind that you can have operations. And so you can't prove that the government order shuts you down for these periods. And this was 2021. So these are, the larger amount. And this was a fairly big and spread out entity. So there's a lot of different stores and things like that. So the numbers were fairly large. Six zeros plus. And so ultimately we were able to tie down and actually pull a local government ordinance for a couple of these restaurants that overrode the state ordinance, right? So you got federal going one way, you got the governor out there going a different way, and then the local city ordinance actually was the one that we were able to use, and actually the client to their benefit, they were following the local ordinances, and that was sufficient enough to prove that those companies were shut down for the period of time. In fact, the local ordinance were more broad than the federal ordinance, and so the IRS came back and added additional ERC, and my client got more money back from the government, as opposed to getting their whatever $1 million of credit removed and having to pay it back. They were actually given a zero audit with a check in the mail, which is, when you do an audit, that's 100% success when you get money back from the government who spent all this money trying to audit them. So that was a interesting one, and it was just such an interesting time, with respect to various different orders going around the rest. Never give up. There might be something out there that you can find that will give you qualification. This particular one, they didn't qualify for the reduced income because they were like a pizza chain. So they were sending pizzas out there, probably making more money than they usually do. So we couldn't get that to stick. So we went to number 2 of the big 2. ERC mill issue. So we kind of talked about this. Promoters, told businesses and owners of businesses that they would be qualified for 26,000 per employee. We talked about in the first one, it's 5,000 max in 2020, 21,000 max in 2021. So if you combine the two, 26,000, there were some nuances, so that could actually go up for different types of employees. So cold calls abound. I received them as an owner of a law firm, tax firm. I knew I didn't qualify. They tried to convince me that I did, which is eye rolling at best. In many cases, these mills are not vetting whether companies qualified. They just wanted to say, hey, did you have employees? Yes. Were you operational? Yes. Send me your stuff. They would just ask for companies' payroll ledgers and their 941s, and they wouldn't look at financials. They wouldn't look at the big 2, whether they qualified for under a government order or under the reduction of income standards or gross receipt standards, and then they would just fill these things out. They had boiler rooms of people just grinding out 941Xs for companies. Millions and millions of dollars were being transferred from the government. The government was not really vetting these at all. And then these companies were taking their fees as a percentage of what the refund was coming back. And so guess where those companies are now? They gone. And so it's up to the company that filed the 941X and I assume put their name at the bottom of it to then defend those funds received. And they're more likely than not, these ERC mills, those that were running them, that money is tantamount to crypto in the Caymans. You're not going to be able to sue those guys, and that they're not going to defend themselves. And so it's going to be up to you to kind of figure it out. And that's just where we are. The IRS's reaction to the rampant fraud. At this point, it's been an issue, and they've identified it. So back in September 23, IRS ordered an immediate stop on all new ERC processing. In October, they actually came up with an idea that said, look, we're talking billions of dollars of filings here. The IRS understood that the nation is just completely over its head with what going on with these ERC mills. And they decided to basically confirm, look, if you know you did something wrong, we're going to allow you to go ahead and just pay us back. And we'll let you pay us back at a 20% discount. We're going to give you 20% of that money for free, even though we know that you did this wrong, And so you're going to get 20% basically free government money. And this was back in October 23. That's how bad, IRS doesn't like to give away money, right? I mean, that's not the IRS's function. And so the fact that they were giving this 20% discount was this huge thing. And I would always advise my clients to take advantage of it. In December of 23, IRS announced that they're expanding the audit to over 20,000 different filings, which is probably just a small portion. I think it's probably about 10% of all the filings, but they were the bigger ones, and they're auditing them all. And so not only do they stop issuing ERCs, they're auditing them, and they're auditing them at a rampant rate. And most of the time when I get a call about an audit, that audit does have some justification. And so they're not just pulling things and randomly hitting people with audits. They're looking into these things. And if you're not showing that notice, if you're not showing that reduction, if you're showing you have too many employees, they're going to have their case built and they're going to be ready to go after it. In 2024, of this March of this year was their most recent announcement. They're ramping up audit, and they've identified over $1 billion and potential fraudulent or errant ERC claims. So this one's going to be going on for a while. I've got a citation below there if you'd like to take a look at this. It's a good just reiteration of all the various different IRS reactions to these ERC claims. So, ultimately what they're looking at is businesses that, qualify, they're not going to get any refunds anytime soon because everything's been shut down. So don't rely on those. Many businesses were duped by ERC mills, so you really want to take advantage of, that October 23 sort of forgiveness provision. The IRS is pursuing better ERC filing aggressively. It's the most audit I've seen on any particular case in my 15 years of doing this. There is going to be fallout for those that signed off on these and they didn't qualify, and they don't take advantage of the withdrawal provision. If you didn't qualify and you go to audit, I'm very good at my job, but I like to tell my clients I'm a pretty good shot, but you got to give me the bullets. And if you show up with an empty gun and I just signed it. This is what the guy told me. I don't know what to tell you. If you don't qualify, then really our main objective there is to make sure that you're not going to get destroyed on penalties, and see what we can do to have you pay that back over time, so that it's not going to take your business into a bankruptcy status because IRS collections on some filing that you didn't know about, which is just a shame. I always say proactive action is required. This slide is actually a little dated. They were going to suspend that October 23 provision for withdrawing those errant accounts. They actually extended it through the remainder of 2024. So if you haven't done it and you're watching this and it's before January of 2024, you still got a chance to get 20% free. And then, obviously you got to come up with the remainder to get back to the IRS, no penalties, no harm, no foul. Long one. This was the end of part 2. The next time we'll go ahead and talk about ERC audits and resolutions. Let's say you don't file for forgiveness. You've missed the boat on that. or if you do get audited and you feel like the audit is errant and can be adjusted, like with the pizza restaurant I discussed earlier, we'll definitely go through that. Once again, my name is Steve Cizik, Harris Law Firm Tax Division. If you have any questions regarding this particular webinar, tax in general, feel free to give me a call or email me and we can go through it.